The darkness continues.
Live from the Michigan Third Circuit Court. It's the game where people try to get out of jail after being arrested. It's time to play the $100,000 get out of jail game. Yeah, I know. Y'all thought it was a ridiculous race game. I had to throw that in there. But, peace, folk, and welcome back to another edition of Proper Thought Series right here on the old T.P.O.T. YouTube page. I'm your host, X, of course, but you knew that already. That's why your black asses are here. Now I'm back with another. And yes, good folk, the darkness does continue. Today, we're in the Michigan Third Circuit Court, and I'm bringing y'all another unfamiliar judge. I'm not sure who this judge is. I'm not sure about her name. So I guess we just gonna have to roll with that. But you're going to see that this judge does have a tendency to let people out, but when she lets them out, the bidding starts at $100,000. And this judge is tough, but she does have a tendency to let people out. So, without further delay, let's get at it. And as always, fair use, Negroes. Fair use. Well, all right. As stated, we are in the 3rd District Court of the state of Michigan. And we're going to play the $100,000 get out of jail game. Our first contestant is this gentleman here. He stands accused of a few things, and we're going to see how he plays the game. So, without further delay, let's get at it. And as always, fair use, Negroes. Fair use.
Hi, what's your name, please?
Jason Lee Cornelius.
All right, Mr. Cornelius, good afternoon. People versus Jason Lee Cornelius.
Well, let me stop it here because this is the first time I've seen this, where this might be magistrate court at this point, because usually when someone is a defendant, you know, they're the accused, there's not a police officer or a member of law enforcement, you know, standing there with them, you know, kind of, I don't know, I guess reading out the charges. I think this is a probable cause magistrate thing here because there's a detective standing there with him. And this is the first time that I've brought this to y'all. So I think that's what's going on here. But we continue. Fair use, Negroes. Fair use.
Counsel.
Austin Gregory, PA 5193, on behalf of Mr. Cornelius, who appears via Zoom, has been made aware of his constitutional rights to waive formal reading and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I will hear your argument as to bond.
Mr. Cornelius understands the serious nature of the charges that he faces. He also notes that it is non-assaultive. He is 38 years old and a lifelong Michigan resident with strong ties to the community. He does have a previous criminal history, Your Honor. The most recent being 10 years, almost 10 years ago. It's from 2013, though, Your Honor. And only one being assaultive. But the case at bay is not an assaultive case. He is employed and has been employed with the same company for the past 5 to 6 years, but he has not worked in the past month. He does receive government assistance, Your Honor. And he does volunteer at the Salvation Army. We do ask for a personal bond, Your Honor, in this case. And we also
What the hell is going on with this guy down at the bottom here? Like, he's he's making these faces. I don't know if he's praying or what. If you look at the freeze frame, he looks like he's about to cry. I don't know what's going on, but we continue.
his file be marked medical as well.
All right, would you please mark the file medical to the jail? Please mark the file medical. Mr. Gregory, do you know if your client was in custody of the MDOC, and if so how long he's been out and off, and how long he's been off parole? Those are two different questions.
Your Honor, I'll briefly voir dire or briefly ask him a question. So, Mr. Cornelius, have you ever been in the custody of MDOC?
Yes, I have been in the custody of MDOC. I have been off parole now since 2016. I want to say like August or September-ish. I'm not sure. Maybe it's before that, but it's in 2016 is when I got off parole.
All right.
I successfully discharged it.
Okay, thank you. All right, Detective, I can see prior felony convictions. Are there any prior assaultive misdemeanor convictions you think I need to be aware of since 2016?
Now, see, this is the part that I haven't seen before, where the detective is literally standing up there with the accused, and the judge is asking the detective, the member of law enforcement, about this person's priors. It's different from Fulton County, because Fulton County, they have something called pre-trial, where they ask the pre-trial person, what's this person's history, how many times they've been arrested, do they have any open cases, et cetera, et cetera. But here, what's going on is they literally have, I guess, the arresting detective or the detective that did the intake on this person after they got arrested. They have the detective literally standing there with the person, I guess, to answer the judge's questions. But we continue. Fair use, Negroes. Fair use.
Not that I know of, ma'am.
All right, thank you.
Thank you.
And I think now this is when the $100,000 game really gets, kicked in, because I'm a true believer that, once the charges are before the judge has pretty much made up their mind, regardless of what the public defender is saying. I think the public defender being there is more of a formality than anything else. I think a lot of times, especially in these cases, that the public defender is there just so it can be said the public defender is there. If y'all can understand what I'm saying, they're basically useless, because I think the judge pretty much their mind is made up way before the public defender even speaks, based on this person's past history, the open cases, the nature of the charge that they face. And now I think the judge pretty much just have their mind made up. So the public defender is just basically there as I guess as your right as a person being arrested. It's your right to have a public defender kind of give a generic, description of you being, you being tied to the community somehow. You're not flight risk. You're not a danger to the community, et cetera, et cetera. They're just basically there to say that. But we continue. Fair use, Negroes. Fair use.
Mr. Cornelius?
Yes, ma'am.
You have a history, it looks like, of theft. If I have to put you on a tether and home confinement to keep you from going out and stealing, They're going to send you to the jail, and you're going to be there for about a week while you wait to get that tether put on. I'm trying to talk because your attorney is going to advise.
Shut your ass up. Shut your ass up. People don't understand. Shut your ass up. Unless the judge asks you a question. Shut your ass up. Yes. But we continue. Fair use, Negroes. Fair use.
As you probably observe your right to remain silent, but I will tell you, I'm not seeing an assaultive risk here necessarily. So I'm that's what I'm struggling with, counsel, is whether or not I need to put a tether on him so that he stops stealing.
I don't know.
Got his finger up. Judge, can I say something? No. Just shut up. Because you listen to the judge. And like I said, I watched a few of this, judge's cases before this. I'm just bringing y'all a few of them. This judge is tough, man. She don't let people out like talk about it. She don't. So he's looking good right now because she's not talking about slapping him with a cash bond, because she usually comes right out with that. But she's not. So she's already made up her mind that she's going to let this dude out, and he's steady trying to talk. Shut your ass up. But we continue. Fair use, Negroes. Fair use.
Your Honor, Mr. Cornelius does understand, and yes, he does have a history of convictions that involve theft. Those convictions are 10 years old, and he has successfully been discharged from parole since 2016. So I do ask that the court give him a personal bond without tether, but I do understand the court's concerns.
And look at him. Just look at him. He don't even have the wherewithal to just stand still and pay attention to what's happening. He's like, God damn it. I gotta get out of here. But this is how it goes when you play the $100,000 get out of jail game. But we continue. Fair use, Negroes. Fair use.
All right. I'm going to do that because I don't see an assaultive risk here. The only assaultive thing I see is back from 2013. It does concern me, quite frankly, but it is 10 years old. Hearing that he successfully completed probation, so that means he went through at least a couple years doing that probably, and now we've got 5 or 6 years after that where we don't have anything else that I'm hearing that I need to be concerned about. $150,000 personal bond. Do not.
God damn. 150,000 personal bond. Now that's a mother. But we continue. Fair use, Negroes. Fair use.
It's your court date, and do not go back to that location, okay?
Yes.
Next court date, January 23rd at 9 a.m. That's for the probable cause conference. Preliminary examination set for January 30th at 9 a.m.
Yes, ma'am.
Okay.
Thank you, Your Honor.
All right. Thank you.
$150,000. That means you screw up on this $150,000 signature bond. You get locked up again. It's $150,000 for your ass to get out. That's tough, especially for like some theft type thing, which I think that's what he's in there for. $150,000. But we continue. Fair use, Negroes. Fair use. And now, our next contestant for the $100,000 get yourself out of jail game will be coming to the stage. Let us continue. Oh yeah, and fair use, Negroes. Fair use.
Unless you guys have another camera where you're doing interviews, counsel, because we're on camera too because of the camera situation.
It appears that we are now at the Detroit Detention Center, so it may be a moment before our next contestant arrives, good folk. And of course, our next contestant walks in here, even though they're inside, they have a damn hood on and 5-inch lashes. But we continue. Fair use, Negroes. Fair use.
All right, what's your name, please?
Marina Thompson.
Okay, Ms. Thompson, good afternoon. This is People versus Marina Thompson, counsel.
Austin Gregory, PA 5193, on behalf of Ms. Thompson, who appears via Zoom, has been made over constitutional rights, waived from reading and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
And again, I don't even know why. Well, I do know why. I shouldn't say that. I do know why, because I guess it's right, for it to be entered into the record of the court. These public defenders, especially when you're talking about initial appearance, they're basically there just to be there, because I'm a true believer that the judge has already made up their mind by the time the public defender speaks. But we continue.
Ms. Thompson understands the nature of the charges that she faces. Does note that one of them is assaultive. That they are misdemeanors. She does live with family, Your Honor. She has 5 children, has been a resident of Detroit for the past 8.
And of course, she's a baby mama 5 times over. But we continue.
8 years, and is 38 years old. She does not have a prior criminal history. And Your Honor, she does understand the no contact order that the court will place on her. Is ready to abide by that and ask for a personal bond in this matter.
All right, thank you. Given the lack of any priors, I did inquire. Given the lack of any priors, the fact that these are charged as misdemeanors, I'm going to set a personal bond here, ma'am. Your personal bond is going to be $100,000. That means you don't.
$100,000. We have another winner, folks. But we continue. Fair use, Negroes. Fair use.
Have to pay it to get out of jail today. But if you violate the conditions of my bond by missing a court date, or most importantly to me, having any contact or attempted contact with the complainant, then that number could attach to you in a very different way. No contact means no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact will be considered a violation of the conditions of the bond. I will amend that to allow you to communicate through a third party for exchange of the children. I do realize sounds like you guys have a number of children in common. So if you need to communicate through a third party for child exchange, you may do so. All right, but other than that, there is to be no contact. January 24th is the next court date. That's a pretrial at 8:30 a.m. in front of Judge Garrett, Austin Garrett. Thank you.
You said January 24th?
January the 24th, Judge Austin Garrett.
Yeah, that was pretty cut and dry, in and out, a quick winner of the $100,000 get out of jail game. So we move on to our next contestant. Dun 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 dun.
Okay, hi, what's your name, please?
Ooh. I will leave the comments to you brothers, but we continue. Fair use, Negroes. Fair use.
Hi, Trisha Robinson.
Okay, People versus Trisha Robinson, counsel.
Austin Gregory, P85193, on behalf of Ms. Robinson, who appears via Zoom, has been made aware of her constitutional rights, waives from reading, and stands mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
Miss Robinson understands the nature of the charges that she faces. She has begun to look for alternative lodging and will stay in the shelter, understanding that she can.
This particular public defender, a lot of I think what it is, not to downplay what the brother does for a living. I think, working for the public defender's office, it's a noble, it's a noble thing. You get in here and you defend, these Negroes that come up in here arrested for all kinds of nonsense. But what I think often happens is the people that come through here, there's not a lot for him to work with. So he has to kind of word salad, some of this stuff. And I know it's not easy to word salad from nothing. Because, when you make a salad, you got to have tomatoes and lettuce and celery and, all kinds of stuff. And basically with a lot of these people, I think all he has is an empty bowl. So it's hard to make the salad with an empty bowl. Just an empty bowl. But we continue. Fair use, Negroes. Fair use.
Go back to the home and have no contact with the complaining witness. She's 36 years old. Does note that while this is an assaultive allegation, she does not have any prior criminal history. She's a lifelong Detroit resident, and she's employed but hasn't been there for some time, Your Honor.
Wait a goddamn minute. How is she employed but has not been there for some time? That didn't make any sense. So she's not employed unless she's on sick leave or something. I don't know, but we continue.
She does suffer from a few medical conditions which are causing her pain currently.
See, the brother don't have nothing to work with, so he like, she's I don't know, 5'10". She wears shoes. She wears pants. She breathes oxygen. She drinks 2 glasses of water a day. But we continue. Fair use, Negroes. Fair use.
And the complaining witness has a few cases that has created some the complaining witness has a prior kidnapping case, Your Honor. So we're asking for a personal bond. Is this all the same complaining witness? Yeah. Oh, the complaining witness also has a felonious assault and domestic violence case, has an assault with intent to murder and carjacking case, and a kidnapping case. And he's been very manipulative. We are asking for a personal bond, Ms. Robinson.
Okay. Let's stop here. because you hear what he's doing, right? Now, I don't know if I agree with this or not. You can come to your own conclusion, good folk. That if someone's a complaining witness, should their record and charges also be displayed at someone's initial appearance or their arraignment? Should that be part of it? If you're accused of doing something to someone, should the public defender be able to say, well, this person that's accusing them, you know, they've been locked up for this and locked up for that, and, you know, they were arrested for this and they did time and all this kind of stuff. Should they be able to do that? I don't know. But we continue. Fair use, Negroes. Fair use.
Does understand no contact order and is eager to observe it. But we do ask for a
It
personal
sounds like
bond.
she needs to observe it for her own safety. I mean, so
I'm with the judge on this one. This dude done have attempted murder charges, kidnapping, felonious assault. Why are you even around this person? Why are you around a person who's been locked up for all of this kind of foolishness and got yourself in a position where he can call the police on you? You heard what the public defender said. Felonious assault, kidnapping, assault with intent to murder or less than murder, something like that. How were you in a position for this person who has this type of criminal history to now call the police on you and now you're arrested? Odd. But we continue. Fair use, Negroes. Fair use.
all right. $100,000 personal bond, ma'am.
Uh-oh. Another $100,000 winner, folk. But we continue.
Thanks to the work of your attorneys over there. You are to have no contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of your bond. That also means you cannot have any contact with the address where this is alleged to have happened. So it sounds like you're working on finding another place to stay. You're going to need to keep working on that. You cannot go back to that location.
Look at the look. Look at the look on her face. She lives with this fool with all this crap on his jacket. She lives with him. She lives with this dude. Look at the look on her face. But we continue. Fair use, Negroes. Fair use.
Understand that you do not have to pay money to get out of jail today. It is, but the personal bond is set at $100,000. That means if you
$100,000. But we continue.
go back there or you attempt any contact with that individual, you may find yourself sitting in there.
Now she's crying. Why do you think she's crying? Why do you good folk think she's crying? She's getting out of jail. The judge is letting her out because this is the $100,000 get out of jail game. So she's a winner. She's getting out. But she's crying. She's crying. She actually did not start crying until after she found out she was getting out. Now, how much you good folk want to bet that this person here has nowhere else to go except where this person is who has been locked up for kidnapping, felonious assault, attempted murder, and every damn thing else? Could that be why she's crying? Could it be? Who knows? But we continue. Fair use, Negroes. Fair use.
Without the ability to get out with that $100,000 number attached to you in a very different way. You are obviously, if this is true, in a very volatile situation with a dangerous individual. I would suggest that you stay away.
Yes. Stay away from him. He got all this going on. All of this is in his history. I say again, how the hell did you get yourself in a position for him to call the police on you and you get arrested? These hoes are stupid. But we continue. Fair use, Negroes. Fair use.
I am ordering you to stay away from that individual in that location. Probable cause conference is set for January 23rd at 8:30 a.m. Preliminary examination is set for January 30th at 8:45 a.m. Those are both set in front of Judge King. Thank you.
Your Honor, I would ask for a one-time police escort, as she will need to get her things in order to be able to be away from the location.
One-time police escort is allowed.
Yeah, go there, get the rest of your shit. But this is the first time, good folk, and I'm pretty sure it's the first time for y'all too. I've never seen a person start crying after they find out they're getting out of jail. I've never seen that. I've never seen a person where the judge is letting them out and they start crying. I've never seen that. I've never seen it. They're usually more like, hooray, you know. She started crying when the judge told her she was getting out. But we continue. Fair use, Negroes. Fair use. And look, still crying even more. Crying even more.
One-time police escort is allowed. And then let's bring Miss LaForge back, please.
Thank you, Your Honor.
You can still hear her crying back there in the background. Still hear her crying back there. All right. Our final contestant for the $100,000 get out of jail game. Blondie here in the orange jumpsuit. But we continue. Fair use, Negroes. Fair use.
All right.
Those are redetermination, or one's called like redetermination. This is redetermination.
All right. You still want a breakout room with Ms. LaForge?
Please, Your Honor.
All right. Thanks.
And good afternoon, it is Honorable.
Hello there, Mr. Bird. Hello. All right. I'm going to send you guys into breakout room 2.
Now, I don't know what's going on with Blondie here because she was up before, before I started recording, and they sent her off, and now she's back, and now they about to go back into another breakout room. I don't know why. This is what they gonna do. So we're going to skip past it, folk, and get to her appearance on this here game. So, all right, we are back here with Blondie. Blondie's back as we conclude the $100,000 get out of jail game. We continue. Fair use, Negroes. Fair use.
All right. Recalling People versus Jade LaForge, counsel.
Austin Gregory, PA 5193, on behalf of Ms. LaForge, who is present via Zoom, has been made aware of her constitutional rights and waives phone reading.
All All right, thank you. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I previously called this case, and quite frankly, since I did the probable cause hearing this morning, had been struggling with what to do with Ms. LaForge and trying to figure out how much of a problem she has with her temper and how likely that makes her to be a danger to the community. One of the things that concerned me was that I inquired about prior assaultive convictions, and I was told that there's a prior assault and battery and a prior resisting obstructing for her, now coupled with what's in front of me. Those having been secured on 2 different dates quite far apart concern me that she has kind of reoccurring issues with her temper and possibly lashing out at others in a physical way.
Now, when I hear judges talk like this, or lawyers, period, it's like they're trying to almost be pseudo-psychologists at this point, right? Because judges are supposed to do what, right? They're supposed to regulate the law and abide by the law. I don't really believe that judges and lawyers should be trying to assess people's mental state. I mean, that kind of stuff I don't agree with. Because you listen to what this judge is saying, you know, she's sitting up here almost trying to talk like a psychologist at this point, instead of talking about the legal precedent. Now, I know as a judge, she's supposed to weigh some determinant factors, but I think those factors should be based on legal precedent, not whether or not this person has a temper, not whether or not this person, you know, lashes out. You hear the words that she's using. All right. This doesn't speak to legal precedent. This speaks to psychological state of mind. And I just don't think a judge, a lawyer, anybody else should be talking like a psychologist, because you're a goddamn lawyer. You're not a therapist. But we continue. Fair use, Negroes. Fair use.
So, counsel, I will hear your bond argument.
Your Honor, first I would like to address the prior criminal history. Ms. LaForge does not have any recollection of the prior convictions that were spoken of. So there may be an issue with the identification or the names that are happening.
Now, that is possible. What the attorney is saying is possible, because he said he ran her sheet and she didn't have any priors. But the judge is saying, oh, yes, she does. But that is possible because guess what? It's possible for someone to have the same exact name as you. That is possible. It's also possible for someone to have the same name as you, have the same date of birth as you. Because that's all they're going by, right? Because if they really wanted to find out, all they really have to do is run her fingerprints through like nicest fingerprint system, and they can find out if she's that person, as opposed to just looking at the names on a sheet and saying this is you, right? But we continue. Fair use, Negroes. Fair use.
But Ms. And additionally, Your Honor, we did make this argument earlier, but she does do hair care. She does take care of her grandmother who's bedridden. She does suffer from severe headaches and back pain, Your Honor, as well. But she most notably
is everybody that freaking come here got some type of physical condition. Notice that the public defender has said that about pretty much everybody. Oh, you know, they have pain. Oh, their back hurt. Their leg hurt. Their eye hurt. They have stomach aches. You know, their tongue hurts when they, you know, drink coffee in the morning. Everybody that comes through here has some kind of pain or ailment. But we continue. Fair use, Negroes. Fair use.
Is a committed member of her family and the community. She does have a local address. She does live with her family, her husband, her daughter, and her 2 dogs. And she does not have a KP.
She rocking back and forth. Why the hell do women do that? Why do they do that? it's like they just can't stand to stand still. Boy, they're rocking back and forth, boy, like a oak tree sapling in the wind, boy, just rocking back and forth, boy, rocking back and forth. Like, what the hell is wrong with them? What is wrong with them brothers? Y'all see her, right? Boy, she just a rocking. What's wrong with you? Is standing still too much? Is standing just still for a few moments too much for your mind to bear? Is that how you regulate your mind? By rocking back and forth like a fool? They're almost like those people, you know, those people on the little bus, you know, they wear the white helmets and they always rocking, you know, forward and backwards and forward and backwards. It's almost like that. That's why I say, amongst us, there is a lot of undiagnosed mental illness. But we continue. Fair use, Negroes. Fair use.
History, Your Honor. So we do ask for a personal bond in this case, with the understanding of her responsibility to the court. And yeah, thank you, Your Honor.
Where does she do hair? Is she doing hair out of her house? Does she have to travel? Does she have to go to
Yes,
work
Your Honor,
someplace?
from her home.
Right. Well, that's helpful. All right.
Well, one thing I can say about the broads that have come up here, unlike in other courts, they haven't said anything. Usually, you know, they blurting out a whole bunch of old foolishness that means nothing when the judge have to tell them to shut up. They haven't said anything. They've kept quiet, which probably works in their favor. Because when you're standing before the judge, if they're not talking to you, the best thing for you to do is what? Shut your ass up. But we continue. Fair use, Negroes. Fair use. But she is steady rocking. She is rocking back and forth. But we continue. I think they be rocking because there's music playing in their head or something. Maybe it's a song playing, you know? She's thinking about some song that's in her head. So, you know, she's like subconsciously rocking back and forth. Because I don't think it's deliberate. I actually think it's subconscious, you know? It's this imaginary music playing in their head. So they like sort of dancing to it, but don't even know they're dancing to it. You know, I think it's something like that, but we continue.
All right, the allegations contained in the investigator's report are concerning. I mean, they're assaultive. There are no prior felonies. She's telling that I can see that we're used to habitualize her. She's telling me she has no knowledge or recollection of any prior convictions. They would be of 10 years old. I will say there are a number of AKAs on this file, main aliases. Okay, so perhaps that is where perhaps there is some confusion in the CCH, the criminal history report.
Well, if that being the case, like I said, it could be other people that have the same name as her, or she's used multiple names in the past. It's one of those, if not both. But we continue. Fair use, Negroes. Fair use.
But nevertheless, the allegations here are concerning enough. The description of the underlying events are concerning enough that I am going to require a GPS tether with home confinement in order to protect the community. But I will set the bond at $100,000 personal. And
we have another winner of the $100,000 get out of jail game. We have another winner. But we continue. Fair use, Negroes. Fair use.
The next court date is going to be the probable cause conference, January 23rd, 8:30 a.m. After that, preliminary examination is set January 30th at 8:45 a.m., both in front of Judge Jones. DDC, it sounds like we need to mark this file medical, please. All right.
Now, they're marking this file medical, which probably means there's something in her case because, you know, they waived the formal reading of the charges. A public defender did. So she probably does have some form of UMI because the judge did say it looks like we need to mark this medical, which usually means they're totally insane. But we continue. Fair use, Negroes. Fair use.
All right. Thank you, everyone. Have a good night.
Your Honor, you do not have a Brown.
I don't have a file on a Brown. I don't recall a PCH on a Brown. Let's see. Hold on one moment.
Okay. So Blondie is getting out, and you can look at her, and the way she's looking right now, you can tell she got UMI. But before we get out of here, it's time for T.P.O.T's bonus clip. Yes, time for a bonus clip, because you know I always got one for y'all. Now, this contestant here, you see standing in the white suit, and from what I understand, when they have on one of these, like these white cloth suits, they either, you know, some type of patient that they're afraid they're gonna try to hang themselves, or the person might have been naked when they were arrested. It's either or, I believe. I'm not sure, but she does stand here in one of these white suits, so we can assume that she either was naked when she was arrested, or she has UMI, undiagnosed mental illness. But we continue. And a side note, this particular contestant is facing similar charges that the people you've seen before are facing. But her outcome is going to be a little different. So we continue. Fair use, Negroes. Fair use.
And let me ask you this, because I did read as well that there's a prior domestic violence case between the parties where she was listed as the victim. Do you know whether the complainant was convicted of domestic violence in that case?
Now y'all are hearing this. Now the person she's accused of doing something to, allegedly, also there was a report of that particular person doing something to her in the past. So you would think that that would play into the decision that will be made with this woman, right? But we continue. Fair use, Negroes. Fair use.
That I do not know, Your Honor. That was simply from Clemens, so we could only say there was a report, no adjudication information.
All right, thank you. I'm trying to understand whether there was a no contact order going on or what was already happening, but perhaps counsel will enlighten me. She has retained counsel. All right, Attorney Nasser, we're going to go ahead into the arraignment portion of this case, People versus Janautica Pratt, who's already...
Janautica? Janautica. Say that 4 times fast. Janautica. But we continue. Fair use, Negroes. Fair use. At least Janautica has a real attorney, not the public defender, who which probably plays well in her favor. But we continue.
Identified herself for the record. Go ahead, counsel.
Yes.
Relate the form of reading and standing your client mute first thing.
I do, Judge. For the record, Mohammed Nasser, P74485. Defendant would waive the formal reading and stand mute. Humbly request the court to enter a not guilty plea on her behalf.
Thank you. All right, court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
First and foremost, the detective has done a very, very thorough job in terms of examining or outlining the alleged facts that have been present here, Judge. However, I want to focus on bond specifically. This court obviously considers, one, the factual circumstance, but two, flight risk and danger to the community. Let's talk about Ms. Pratt. Ms. Pratt, I know her personally. I know her family personally. She's 20.
Oh, so he's a friend of the family. It's always good to know a lawyer. Shoot, I know, three? Yeah, I know three. So, yeah. But we continue.
26 years of age. She works as a physical therapist assistant at Uville Skin Treatment Center. She's a mother of one minor child. More aptly and more specifically, Judge, she already has an alternate residence to stay at as this matter is pending. That address is 8824 Parkwood in Belleville. She'll be staying with a family member. Certainly, she will not be in the city of Canton. As it relates to prior criminal acts or the like, the only thing that she had, Judge, was back in 2016. It was out of Westland. And I'm looking at the register of actions. That case was successfully closed. 2016 would have made her 18 or 19. And it was an incident at school that she had. She has no record whatsoever. I don't see any probation violations. Certainly my assistant is looking through, and if there is, we will address it, but I do not see it. As it relates to traffic, Judge, her family's retained me to address all matters, and I will certainly file an appearance to set aside the traffic warrant and address that personally. Specifically as it relates to bond, Judge, and this court's inquiry is appropriate. There has been a history of domestic violence that has been predicated here, and my client has been the victim of that. And the complainant, Mr. Roby, or in this instance, the complainant, Mr. Roby, has been the quote unquote assailant in the other instances, which has certainly aggravated Ms. Pratt's response to this particular incident.
Now you hear her attorney, who you hear, but you cannot see. And he's putting forth that, hey, you know, this particular lady here who's accused of, I believe, firing a weapon at the man. She might have shot him. She was the victim of this same person. Now, her lawyer is saying that, you know, she has no record. She hasn't done anything for the past 6 years, right? Since she was like 18. She's 26 now. So you're talking 8 years ago. So she has a very minimal criminal history. You know, all of that should be playing in her favor, on top of the fact that the person that she's accused or allegedly assaulted her previously in the past. So you would think this stuff would play in her favor, right? But we continue. Fair use, Negroes. Fair use.
That being said, we certainly understand the significance of the allegations that are being made here today. Ms. Pratt understands the significance or the gift that can be awarded by this court as it relates to bond. Judge, she, again, with no prior felony record whatsoever, retained counsel. People don't retain me and or my firm if they're going to run. She's not going to run. I can speak that with confidence. We have also reached out to Abundant Community Recovery Services, which is located at 1660 Oakman Boulevard in the city of Detroit. Miss Tanya Murphy is her therapist and was previously her therapist as it relates to being a victim of domestic violence. Miss Murphy has advised me that if this court is so kind to allocate bond, that she will once again begin treatment with Miss Pratt. There's also bed space available at Abundant Community Recovery Services if the court deems it appropriate to have her situated actually in Abundant. However, Judge, based upon the fact that she has employment as well, what I'm asking this court is to consider two things. One, based upon the lack of felony convictions and the limited misdemeanor conviction that she had when she was 18 or 19, which she should have gotten HIDA for, so I don't understand it. But that being said, I'm going to address that. However, Judge, there are conditions or a set of conditions that this court can bestow.
Now, the lawyer is pretty much throwing a big old word salad at the judge at this point, but we continue.
Would ask for a GPS tether. Certainly, I would ask for her not to return to the incident location, which was a shared residence between her and Mr. Roby. She does have the alternate residence where she's going to stay at. So I'm asking this court to consider a reasonable bond. I would ask this court to consider a reasonable bond based upon the allegations that have been presented here. I would ask for 30,000, 10% GPS tether. And I know that the GPS tether is going to delay this process. However, I want to allay this court's concerns as it relates to any possible contact with Mr. Roby. The detective did indicate that Mr. Roby didn't make a statement, and nor did he remember the allegations. From what I have been advised, Mr. Roby does not want to proceed forward. That being said, that's neither here nor there as it relates to the allegations that are being presented here today, Judge. However, I do believe that a reasonable bond is appropriate, and I believe the bond in the area of 30 to 40,000, 10% with GPS tether will allay these concerns. And again, there is a history here, and that is why I'm asking for a GPS tether to ensure that Mr. Roby is not around Ms. Pratt. Ms. Pratt and her family have assured me that she will certainly not be around Mr. Roby, and we will address this accordingly.
Okay, thank you. What was the prior conviction for her that she was on probation for, please?
It was a misdemeanor. It was a fight in high school, Judge. So it was a misdemeanor assault and battery. Ultimately, she was given 12 months of probation. It says closed pursuant to the ICHAD.
Okay, thank you. And then you referenced history of domestic violence. I've read about one incident in the investigator's report. Are you aware of others or other cases? Not
I'm
other
aware.
just complaints. Are you aware of any other domestic violence cases between the parties?
There are no official cases, but I'm aware of numerous instances, which is what the family has advised me, and which is what the therapist and what limitedly she could tell me has indicated that in treating Ms. Pratt, that she has a history of domestic violence with the same father of said child.
So basically what he's saying here is that, her and her baby daddy be fighting a lot. And there is one official report on paper that, he, I guess beat her up or, did something to her. And maybe she just got tired of it, and got tired of him and kaplow, 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 Negro. And, when it comes to this type of stuff, if a woman is constantly getting beat by a guy, and I'm no fan of women doing things, to men or anybody for that matter. But if you a dude and you steady beating on a woman, I'm not mad at her if she turns around and shoots your ass, Negro. I can't be mad at her. I just can't. But we continue. Fair use, Negroes. Fair use.
So that's what I'm speaking to. I do know that the detective mentioned a singular case. However, in speaking to the family and to limitedly to the therapist who can't provide me everything without Ms. Pratt being present, that there have been numerous instances, whether or not they've been reported or not, but there has been a history.
Okay. All right.
Can I get this P number, Your Honor?
Yeah, Attorney Nasser, what's your P number, please?
My apologies, Judge. It's 74485.
You mentioned Abundant Community Recovery Services having a bed available. Is she eligible for a bed there?
Now, like I said earlier, this is a tough judge, but she's going into a deep inquiry as far as this woman is concerned. Because one thing about female judges, if they hear that a woman is being abused by a man, they kind of, they're somewhat empathetic to it. All right? They're somewhat empathetic to it. More empathetic than they are to a woman doing something to a man. If a woman commits domestic violence towards a man, I think the common belief is that, she's doing it to strike back. Now, in this particular case, that's kind of how it appears on the surface. That's how it looks on the surface. And I think that's what the judge is mulling over. Now, I don't know for sure, but it's a possibility. But we continue. Fair use, Negroes. Fair use.
Absolutely. And Ms. Murphy, who's the chief therapist at Abundant Community Recovery, I spoke to her prior to logging on here today, and it indicated to me that I can make the representation to the court that If this court so deemed fit, she will be given bed space over there. And certainly that is an inpatient facility. And I should say that, an evaluation by the therapist outlining some of the history, I think will speak volumes as it relates to perhaps her conduct. The officer did say she was cooperative and provided a statement, certainly outside of the advice of her counsel. But that being said, I think it'll be irrelevant in terms of any type of resolution in this matter.
Okay. All right, counsel. Here's what we're going to do. I always have concerns about possible escalation in these situations, especially where I've got stuff flying from both sides. I am concerned that a firearm was discharged, but I do understand that there is a history here.
You hear that, right? I do understand that there's a history here. Ergo, the empathy. But we continue.
I'm going to set bond in the amount of $30,000, 10%.
$30,000. Now remember, this is the $100,000 get out of jail game. But this contestant here, $30,000. But we continue. Fair use, Negroes. Fair use.
However, I am also going to require a GPS tether, and I want her tethered to Abundant Community Recovery Services.
Oh, yeah, she's got to go into a domestic violent rehab center. Yeah, she's got to go into domestic violence rehab right out of the jail. After she posts that $3,000, she must report directly to domestic violence rehabilitation. Because she went kaplow, kaplow, kaplow with the pistol. But we continue. Fair use, Negroes. Fair use.
That is where I want her released to Abundant Community. Okay. And I want her confined there as if she was on home confinement. She will be confined there, not to leave until a judge says otherwise. All right. There's, of course, also going to be a no contact with the complainant. No verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. She's not to purchase or possess any firearms or other dangerous weapons during the course of the bond. And there's also going to be a no contact with that address where this is alleged to have happened until a judge says otherwise. The next hearing is going to be a probable cause conference on January the 27th. That's an in-person hearing at 9:00 a.m. After that, preliminary examination is set for February 3rd at 9 a.m.
Thank you kindly, Judge. Always a pleasure to be before this honorable court.
All right. Thank you.
Quit kissing the judge's ass. But what do y'all think about this? I believe that this particular judge would have set the bond higher. As y'all can see, even when she gives you a signature bond, the bidding starts at $100,000. But this particular case, the bond is only $30,000, right? So 10% of that, $3,000, she's out the door. But with this woman, she's out the door, but she has to go to, whatever this place is. I'm assuming it's somewhere where you can get therapy about domestic violence. So I do think there's a degree of empathy there and humanity with the judge. And this judge is tough, all right? This is a tough judge, as y'all can probably see from what you saw thus far. The judge is tough, but she went easy on this particular person based on her circumstances. And you got to give her lawyer some credit too, because he laid it down and he hit her with a gigantic word salad with all the verbal tomatoes, lettuce, onions, and celery, and everything else. So I think that had a lot to do with it. And she got off easy with this particular judge. She got off easy. So hopefully she doesn't screw this up. Hopefully she don't go shoot her baby daddy again. And maybe, just maybe, she'll take this opportunity that the judge has put before her and straighten up. Now, I say again, she got on one of these white smocks. And you know, when they got on the white smock, either one or two things happened. They either got arrested when they were naked, or they suffer from UMI. We'll see. But that's all. I appreciate y'all coming through, man, and checking this out. You could have spent your time anywhere. You decided to spend it here with T.P.O.T, and it is appreciated. I don't take you good folks lightly, man. I never have, and I never will. You got my word on that. So, with that, I will leave you good folk with 3 words you know, like I always do. Open your mind. Peace, folk. X with another.
The darkness continues.
Only from T.P.O.T Media. Open